Okay, we'll get started. As I put in the chat feature, which hopefully everyone can view, my name is Kristen O'Neill. I am the Assistant Director of the Committee on Open Government, and today we'll be just doing an overview and an update on the Open Meetings Law for people that are not familiar with the statute, to give them an overview, and for people that are familiar with the statute but want to become knowledgeable about the changes that have occurred in the past year, 2 years, since the start of the pandemic. We'll be going over those issues as well. If you have questions about something that I've discussed, if you'd like to put that in the chat feature, because that's where I'll be looking for questions and answers, I would ask that you wait until we've discussed the issue to pose your questions, because we'll be taking the questions at the end of the program. So there's a good chance that if you have a question right now, that hopefully it will be addressed during the program. So if you want to at least wait until we've covered the subject matter that you're curious about before putting a question in the chat feature. This program is being recorded, and it will be available on our website. There's a section on our homepage of our website for retraining materials. The PowerPoint that you see right now, there's a copy of this PowerPoint on our website, and a recording of this training program will also be available on our website. So if you go to our homepage, scroll down a bit, you'll see a box that contains a link to training materials and recordings. So I just, as a courtesy, I just ask that that you don't send individual requests to me for copies of the materials and the recordings, because they are going to be available on our website. Because of the holidays, I can't promise that the recording is going to be up anytime very soon. I'm not sure what our web staff, what their holiday schedule is like, so be patient if you don't see it right away in the next week or so. It will get up there soon. Okay, we'll get started. My name, my email address, our office telephone number. We're a small staff. We're a staff of 4 attorneys and 1 administrative assistant. So if you call the phone number that you see up on the screen right now, you can ask to speak to one of the attorneys in the office, and any one of us can assist you with your inquiries. Up there you'll see right now is our website as well, www.opengovernment.ny.gov. If you have questions directed to me specifically, you can use my email address, but at the end of the program, I'm going to give you an email address that will be directed to our office as a whole, and that means that the first attorney that can get to your question will get back to you, which means you'll get an answer probably more quickly than if you email me directly. The Open Meetings Law is codified in Public Officers Law, Article 7. And you can find a copy of the Open Meetings Law. We try to keep it as up-to-date as possible. Whenever there's an amendment to the Open Meetings Law, we incorporate that into the version that is posted on our website. So if you go to opengovernment.ny.gov, you will find a copy of the statute. The Open Meetings Law was passed in 1976. The declared legislative intent stated that it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. Citizens had and have the right to attend and listen to the deliberations and decisions that go into the making of public policy. At the start of my program today, I'm going to talk a bit about the recent amendments to the Open Meetings Law with regard to video conferencing. So those of you that have a basic knowledge of the Open Meetings Law, we are going to go in a little bit in reverse. Instead of talking about the basics of the Open Meetings Law first, we are going to talk about the specific aspects relating to video conferencing, and even more specifically, extraordinary circumstances video conferencing. So in April of this year, Governor Hochul signed Chapter 56 of the laws of 2022, which was part of the New York State 22-23 fiscal year budget. Included in the bill was an amendment to the open meetings law to make semi-permanent. When I say semi-permanent, I mean that there's an expiration date on the amendment. It's in effect until July 1st, 24, the amended language that expands the use of video conferencing by public bodies to conduct open meetings under extraordinary circumstances, regardless of a declaration of emergency. For those of you that work in local government or are familiar with the requirements of the open meetings law, you'll know that since the start of the pandemic, there have been provisions in place that allowed public bodies to have fully remote meetings. Those provisions are no longer in place. There is no statewide authorization for fully remote meetings anymore. That ended in mid-September of this year. So now either meetings must be in person to a large extent, but this amendment gave a little bit of extra leeway to the public bodies to allow members to participate via video conferencing from private locations under extraordinary circumstances. As a threshold matter, it's our understanding that this new amendment was not meant to change or curtail what has always been required of public bodies complying with the open meetings law. Public bodies may also continue to operate now as they did before the onset of the pandemic in early 2020, when the in-person aspect of the open meetings law were first suspended. In other words, we believe that if a public body was permitted to do it before the pandemic, this law does not change that. This law is intended to expand, in extraordinary circumstances only, the ability of public bodies to meet using remote access technology. So with the introduction of Chapter 56, public bodies now have two ways to use video conferencing technology to conduct an open meeting. The first way is the way that has existed for many years now, in that a public body can connect multiple physical locations that are open to in-person public attendance. So what that means, for example, is the Committee on Open Government for several years now. We have members of our committee that live and work all over the state of New York. So what we do, and what we've been doing for years and has been authorized by the Open Meetings Law for many years, is to have multiple physical locations that are open to the public. One in Buffalo, one in Albany, one in New York City. That's just our example. And all of those locations are open to in-person public attendance. The member of the body chooses the site that is most convenient for them. They attend from that site, and all of those sites are connected through the use of video conferencing. So that's the first way that video conferencing can be used, and that has existed for quite a while now. The second way that video conferencing can be used is the new way that was introduced in April of 22 by Chapter 56. And this allows a member of a public body to participate from a private location through video conferencing, but only under extraordinary circumstances. If a public body is using the first type of video conferencing, connecting multiple physical locations that are open to the public, this new Section 103A, which is the section that was added by Chapter 56, does not apply. If you're using the old way of video conferencing, this new language is not relevant to you. It doesn't matter. You don't need to worry about it. You only need to worry about the new requirements of the Open Meetings Law if you are connecting or if you are allowing a member of a public body to attend from a private, closed location under extraordinary circumstances. So what the law states is that a public body may, in its discretion, use video conferencing to conduct its meeting pursuant to the requirements of this article, provided that a minimum number of members are present to fulfill the public body's quorum requirements in the same physical location or locations where the public can attend. So what this means is the people that attend via extraordinary circumstances video conferencing from private locations will not count towards a quorum. You have to have a quorum of your public body present at a location, a single location or one of the multiple locations that are open to the public. If you can't get your quorum by having members attend at public locations, then you should reschedule your meeting, because the people that attend from private locations via video conferencing are not going to count towards your quorum. And this was intentional on the part of the legislature, is our understanding. Chapter 56 requires that the governing board of a county, city, town, or village must adopt a local law, and all other public bodies other than the Senate and Assembly must adopt a resolution following a public hearing. That means all public bodies, whether you're a governing board of a county, city, town, or village, or whether you are an entity such as us, the Committee on Open Government, everyone is required to have a public hearing prior to either adopting a local law or adopting a resolution authorizing the use of extraordinary circumstances video conferencing. The governing board or the public body can pass this resolution for itself in all of its committees or subcommittees, or it can specify that each committee or subcommittee can make its own determination. If you'll see it, that Roman numeral 3 has to do with community boards in New York City. So if you're somebody that is listening in from a community board, the law authorizes that each community board in New York City must make its own determination with regard to the use of video conferencing. Every public body that decides to allow for extraordinary circumstances video conferencing must establish written procedures governing member and public attendance consistent with these new requirements, and the procedures must be conspicuously posted on the public body's website. So this again goes to quorum requirements and physical presence. The new amendment clarifies that members of the public body must be physically present at any meeting unless the member is unable to be physically present due to extraordinary circumstances. So again, the assumption is that you're going to be there in person. The preference of the legislature is that members of a public body attend in person at public locations. But this provision allows a member to participate via video conferencing under extraordinary circumstances as set forth in the public body's resolution and written procedures. That the examples that the legislature gives include disability, illness, caregiving responsibility, or any other significant or unexpected factor or event which precludes the member's physical attendance at the meeting. The law allows each public body to define what they consider to be extraordinary circumstances. It also is silent as to the procedure for authorizing someone to attend via extraordinary circumstances. That is something that each public body needs to determine in their procedures. How are we going to determine whether a particular member can attend the extraordinary circumstances video conferencing? That should be laid out in each public body's policies and procedures. Except in the case of executive sessions, which do not need to be open to the public bodies shall ensure that members of the public body can be heard, seen, and identified while the meeting is being conducted, included but not limited to any other motions, proposals, resolutions, and any other matter formally discussed or voted upon. So what this means is back during the pandemic, a member of a public body could participate through teleconference or through the use of video conferencing with their cameras turned off. That's no longer allowed. If you are a member of a public body, the public needs to be able to see you, hear you, and see you And you need to be able to be identified. Means when you log on to WebEx or Zoom or whatever your program is, you should be typing your full name into the program so that you are identified on the screen by your name. And you need to have your camera on pretty much at all times. The new requirements, the new statutory requirement states that the minutes of the meeting involving extraordinary circumstances video conferencing shall include which, if any, members participated remotely and must be available to the public pursuant to Section 106 of the Open Meetings Law, which is the section of the Open Meetings Law that relates to meeting minutes generally. The law also states that if extraordinary circumstances video conferencing is used to conduct a meeting, the public notice for the meeting shall inform the public that video conferencing will be used, where the public can view and or participate in such meetings, where required documents and records will be posted or available, and it must identify the physical location for the meeting where the public can attend. The public body shall provide that each meeting conducted using extraordinary circumstances video conferencing shall be recorded, and such recordings posted or linked on the public website of the body within 5 business days following the meeting, and shall remain so available for a minimum of 5 years thereafter. And the recording shall be transcribed upon request. So if you are allowing your members to attend via extraordinary circumstances video conferencing, that meeting must be recorded, must be posted on your website within 5 business days, and it has to stay up for a minimum of 5 years. Just to sort of ward off any questions about why the legislature came to certain decisions that they came to, I can tell you that I don't know. We were not involved in the legislative negotiations. We became aware of these amendments right around the same time that everyone else did. We were not part of the discussion to decide what the requirements were going to be. If extraordinary circumstances video conferencing is used to conduct a meeting, the public body shall provide the opportunity for members of the public to view such meeting via video and to participate in proceedings via video conference in real time where public comment or participation is authorized. It must ensure that video conferencing authorizes the same public participation or testimony as in-person participation or testimony. So again, if you're allowing one of your members to attend via extraordinary circumstances video conferencing, the public has to also have the right to view the meeting. In addition, if you allow the people that attend your meetings in person to participate in a public comment period, then you must also allow the people that are attending via video conferencing to participate, to participate in the public comment period. The same rules that apply to the people that attend in person have to apply to the people that are attending virtually. The law states that a local public body that elects to use extraordinary circumstances video conferencing to conduct its meetings must maintain an official website. So if you're one of the very few local public bodies that has not yet gotten a website up and running, then if you want to take advantage of the benefits of this new provision, you must get a website up so that you're able to host recordings of the meetings. The in-person participation requirements of the Open Meetings Law, specifically of this new language that requires all members to attend via physically in person unless there's an extraordinary circumstances, shall not apply during a state disaster emergency declared by the governor or a local state of emergency proclaimed by the chief executive of a county, city, village, or town, if the public body determines that the circumstances necessitating the emergency declaration would affect or impair the ability of the public body to hold an in-person meeting. So, for example, if a worst case scenario, occurs and perhaps our COVID numbers get significantly worse again, we get back into a terrible situation with the pandemic, and Governor Hochul decides she needs to declare another disaster emergency statewide, and the public body believes that state of emergency prohibits them from having in-person meetings, the public body can choose to have fully remote meetings instead. The same is true, it's my understanding, and this may not be true anymore, but it was up until recently. For example, that New York City still had a state of emergency in effect relating to the COVID pandemic. If the public bodies that are located within New York City believe this emergency declaration that exists only in New York City affects or impairs the ability of the public body to hold an in-person meeting, they too can have fully remote meetings. Some people have asked questions along the lines of, well, there's a monkeypox state of emergency, there's a polio state of emergency, but the question that really matters here is, does that emergency declaration affect or impair the ability of the public body to hold an in-person meeting? The likelihood is that the fact that there's a monkeypox state of emergency, statewide state of emergency, is not going to affect or impair the ability of a public body somewhere in the state of New York to hold an in-person meeting. So it's not enough that there's just a state of emergency. You have to connect the state of emergency to the ability of the public body to hold an in-person meeting. Last week, we started to get questions about bad weather, inclement weather. And my feeling is no. Well, first of all, inclement weather in itself is not enough to declare, to state, let me back up a little, having inclement weather enough is not enough under the statute to have a fully remote meeting. If your local municipality, either at the city level or the county level, declares a state of emergency relating to that inclement weather, and that state of emergency affects or impairs the ability of the public body to hold an in-person meeting, you may be able to go ahead with a fully virtual meeting. But what I would ask the public body to do is determine whether it's absolutely necessary to have the meeting at that point, or can it be postponed. Because if you are making a last-minute decision to move something from in-person to virtual, you may not be able to comply with the required notice provisions, and it may just be better to postpone the meeting. No later than about a year from now, the Committee on Open Government is required to issue a report to the governor and the legislature concerning the application and implementation of these amendments, and we're required to make any further recommendations governing the use of video conferencing by public bodies to conduct meetings pursuant to this section. So as we progress over this coming year, we ask that individuals, whether you are a member of the public, whether you're a member of the media, whether you're a representative of local government, let us know how things are going with these provisions. How is it working? What might be suggested improvements for the use of video conferencing to conduct public meetings? From the start, we've asked people not to just express their fears about what might happen, but let us know how things are actually in practice happening. Because back at the beginning of the pandemic, everybody had a lot of fears about the use of remote meetings and having their meetings through remote technology. But as things progressed, turned out people really liked having those remote meeting options. So our preference would be for people to let us know how things are actually going, as opposed to how they fear things might go. Open meetings of a public body that are broadcast or that use video conferencing must use technology to permit access by members of the public with disabilities consistent with the 1990 Americans with Disability Act. For the purpose of this section, disability is defined by New York State Executive Law, Section 292. Our office is not qualified to provide advice regarding the Americans with Disabilities Act. My recommendation for anyone who is a member of a public body or works for an agency that hosts public bodies is to consult with legal counsel, where that is an area that they've studied and they are very familiar with the requirements of the Americans with Disabilities Act. But I would say our office is not particularly qualified to provide that guidance. So there's stopping for a moment. That is my overview of these new amendments. And now we are going to move on to the overview of the statute generally. So the Open Meetings Law governs the conduct of meetings of public bodies, and that term has a very long definition. It didn't used to be quite this long, but it became much longer in the past year and a half. And it's any entity for which a quorum is required in order to conduct public business and which consists of 2 or more members performing a governmental function for the state or for an agency or department thereof, or for a public corporation as defined in Section 66 of the General Construction Law. So that's sort of the primary part of the definition. And then it goes on to say that it includes committees or subcommittees or other similar bodies consisting of members of such public body. So for example, if you are a county legislature that has 15 members, the county legislature is a public body, but so is, for example, the 5-member or 3-member finance committee or human resources committee or highways committee, whatever those committees are that are made up entirely or primarily of members of the full county legislature, as an example. That committee or subcommittee is also a public body that must comply with the Open Meetings Law. Any entity created or appointed to perform a necessary function in the decision-making process for which a quorum is required in order to conduct public business and which consists of 2 or more members. That's very lengthy, but this was language that was added through legislation in the past year and a half. It's any entity created or appointed to perform a necessary function in the decision-making process. The statute then goes on to clarify that a necessary function in the decision-making process shall not include the provisions of the recommendations. Should not include the provision of recommendations or guidance which is purely advisory, which does not require further action by the state or agency or public corporation. So that's new language, which sometimes makes things a little bit confusing in terms of public bodies. But I think what people should remember is that this language was really intended to clarify what the Committee on Open Government has been advising for many years. If you are an entity that serves a necessary function in the decision-making process and you have been created by statute, you're likely going to be considered a public body subject to the Open Meetings Law. If you are purely advisory in nature, if you are an entity that is created, for example, your town supervisor decides that they want to have a Parks and Recreation Committee that is made up of members of the public, maybe business owners, and 1 liaison from the town board, and that entity does not have any final decision-making authority or doesn't have any authority to spend municipal monies, then that entity is probably not going to be considered to be a public body subject to the Open Meetings Law. Determining whether an entity is a public body can often be very factually specific, and that's something that we would encourage you, if you are questioning whether an entity is a public body subject to the Open Meetings Law, that is something that we can help you figure out if you reach out to us and provide as much detail as possible regarding the entity you're questioning. So question yourself, have 2 or more people been given the authority to act collectively? Is a quorum necessary in order to conduct public business? Is the committee made up solely or primarily of members of the larger public body? Does the committee serve a state statutory function? In the alternative, is the entity purely advisory in nature with no statutory duties or final decision-making authority? Those are the questions that a public body is going to want to ask itself in determining whether they believe they're subject to the open meetings law. I've used the word quorum a couple of times just for clarity's sake. The term quorum is defined in general construction law. States whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly or as a board or similar body, a majority of the whole number of such persons or officers gathered together in the presence of each other or through the use of video conferencing shall constitute a quorum. Not less than a majority of the whole number may perform and exercise such power, authority, or duty. And then for the purpose of this provision, the words whole number shall be construed to mean the total number which the body would have were there no vacancies and were none of the persons or officers disqualified from acting. So for example, the Committee on Open Government is an 11-member body when we're at full strength. Quorum of the Committee on Open Government is always 6, even though right now we only have 9 individuals appointed to serve on the committee. We're 2 people short in terms of appointments. But even though we're 2 people short and we have only 9 people serving on the committee at this moment, there are 2 vacancies. We still determine quorum based on the full number 11. So quorum is always going to be 6, no matter how many people are currently serving or how many people are actually present at the meeting. So as a reminder, members who are participating from a physical location that has been properly noticed and is open to in-person public attendance do count towards a quorum. They can fully participate and they can vote. Members who are video conferencing from a remote location that is not open to in-person public attendance do not count towards a quorum. However, they may fully participate and vote if a quorum has otherwise been met. So if you have a 5-member town board and 1 member is video conferencing from a private location out of state, if you have a quorum physically present at town hall and that extraordinary circumstances video conferencing has been authorized by the town, then that 5th member can fully participate and vote. However, if you only have 2 people show up in person at an open location, you're going to probably need to cancel the meeting because you don't have a quorum present at an open location. Notice of the meeting. Notice of the meeting, the date, time, location, and if appropriate, instructions for virtual attendance must be given prior to every meeting to the media. This does not mean a public body is required to purchase a legal notice. It just means that notice must be given to the media. The notice must be placed in a designated physical location. If the agency or public body has an active website, it must be posted on that website. In terms of timing, notice must be given at least 72 hours prior to any meeting that is scheduled at least 1 week in advance. For meetings that are held on short notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. The open meetings law itself is silent in regard to when a public body is allowed to have meetings on short notice. However, the courts have not been silent. The courts have suggested that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. Public bodies should look to see whether any harm would be caused by waiting. If no harm would be caused by waiting, they should probably wait until they can provide the full amount of notice. If something comes up where it really needs to be taken care of as quickly as possible, then the law allows you to have a meeting on short notice. If extraordinary circumstances, video conferencing is used to conduct a meeting, the public notice must inform the public that video conferencing will be used, where the public can view and participate in the meeting, where required documents and records will be posted or available, and identify the physical location for the meeting where the public can attend. Those are all the provisions relating to notice. On October 19th of 2021, Governor Hochul signed into law Chapter 481 of the laws of 2021, which amended Section 103 of the Open Meetings Law. Now, I emphasize the word amended because many people at the time that this law was passed thought this was a completely new requirement and didn't realize that there was an obligation to post records scheduled to be discussed. That has been in effect since 2012, so over 10 years now. But Chapter 481 amended Section 103E to require that the records to be discussed at a meeting be made available to the extent practicable upon request and posted online at least 24 hours before the meeting. As I mentioned, the obligation to make records available to the public upon request prior to or at the meeting and to post the records on the agency or public website prior to the meeting has been in effect since February 2012. This amendment simply places a 24-hour minimum time frame for making those records available. So where it used to say just prior to or at the meeting, the law now says at least 24 hours before the meeting. That's the only change that this amendment made. Unfortunately, many people thought this was a brand new obligation to make records available, which means they had not paid attention to the Open Meetings Law for the past 10 years. So this provision relates to any proposed resolutions, laws, rules, regulations, policies, or any amendments thereto. It applies to any records or portions thereof that are public under the Freedom of Information Law that are scheduled to be discussed during the open meeting. They must be made available upon request at least 24 hours prior to the meeting, must be made available online at least 24 hours prior to the meeting, and but only if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. The agency is not required to spend additional money to implement this section. Minutes. Minutes of a meeting must include all motions, proposals, resolutions, or any other matter formally voted upon and the vote thereon. If extraordinary circumstances video conferencing is used, it must include which, if any, members participated remotely. Minutes of an executive session are only required to be prepared if the public body votes in executive session. If there's only deliberations in executive session, no minutes need to be prepared of the executive session. But if there's a vote in executive session, minutes must be prepared. The minutes must be prepared and made available within 2 weeks for open session and within 1 week for an executive session. If someone asks for copies of those minutes, they must be made available, and it does not matter whether the minutes are still unapproved or in draft form. There's nothing in the Open Meetings Law that requires minutes be approved. I'm not saying that there's anything wrong with that practice. Looking at Open Government also reviews and votes to approve minutes at the next regularly scheduled meeting. However, it's not a statutory requirement. If the minutes are drafted, once they've been drafted, if someone asks for them, they must be made available. In addition, on November 8th of 2021, Governor Hochul signed into law Chapter 587 of the laws of 2021, which amends the Open Meetings Law to require agencies that maintain a website and use a high-speed internet connection must post their meeting minutes on their website within 2 weeks of the date of the meeting or within 1 week of an executive session. The law further states, for purposes of this subdivision, unabridged video recordings or unabridged audio recordings or unabridged written transcripts may be deemed to be meeting minutes. Nothing in this section shall require the creation of minutes if the public body would not otherwise take them. So let me clarify something here because this has caused a little bit of confusion. This language that I quote at the bottom of the PowerPoint was not intended to allow public bodies to just have recordings or just have transcripts in lieu of meeting minutes. Meeting minutes must still be prepared no matter what. Meeting minutes are always going to be required to be prepared. However, if instead of posting meeting minutes, A public body would prefer to post online unabridged video recordings, unabridged audio recordings, or unabridged written transcripts, they can do that instead of posting the meeting minutes. However, still need to prepare the meeting minutes within the time limit set forth in statute, and those meeting minutes must still be available upon request. Also point out here, meeting minutes and transcripts are not the same thing. A transcript is not meeting minutes. If you have a transcript of a meeting, that is not sufficient to comply with the obligation to prepare meeting minutes. Meeting minutes should be a simple document that sets forth the basics of what occurred at a meeting. Nobody should be obligated to dig through pages and pages, perhaps hundreds of pages of a transcript in order to find out the basics of what occurred at that meeting, what actions were taken at a meeting. Meeting minutes must always be prepared, and transcripts should not be considered an alternative to preparing meeting minutes. Recordings. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and/or transmitted by audio or video means. If you are a member of the public and you would like to record a meeting or take pictures at a meeting, you are authorized to do so. You do not need to let anyone know that you're doing it. You don't need a public body's permission to do it, as long as you're not being disruptive. An agency may establish reasonable rules to limit disruption and interference, and we have, the Committee on Open Government has model rules for that on our website. If a meeting is being held fully in person, an agency is not obligated to record its meeting. However, if a meeting is being, if that extraordinary circumstances video conferencing is being used, then Section 103A of the Open Meetings Law requires a public body to record its meetings. Executive session. Executive session, as defined in Section 102 of the Open Meetings Law, is a portion of an open meeting that is not open to the public. So it's a portion of an open meeting. It is not a section of it is not prior to or separate from an open meeting. In order to enter into executive session, a public body must first have an open meeting that has been noticed properly to the public, where the public has been invited in, is allowed to listen and observe the public body, and while the public is there, or potentially at least has the right to be there, a motion must be made by the public body and voted upon during an open meeting to enter into executive session. The motion to enter into executive session is supposed to be specific enough to reflect to fellow board members and to the public that the public body is entering into executive session for a proper purpose. It does not need to be so specific that it defeats the purpose of the executive session. Here up on the screen, you'll see a list of the permissible reasons for entering into executive session. If you don't see it on this list, that means you can't go into executive session. The legislature was very specific with what they are authorizing a public body to discuss in executive session. So you have to look to the statute. If you see the rationale for entering into executive session in the language of the statute, then you're good. You're going to want to use language that properly reflects that you're going in for a proper purpose. The courts have indicated that they don't want public bodies merely sort of parroting the language of the statute. Sometimes this can be difficult, it's just a fine line, but I'll use an example. You'll notice, I'll go on to my next slide where I'm telling people, don't use the word personnel. Please don't make a motion to enter into executive session to discuss personnel matters. It is not sufficient to reflect to your board and to the public that you're entering into executive session for a proper purpose. The word personnel is not used in the Open Meetings Law. What is used is language that allows a public body to enter into executive session to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. So when the courts look to see whether motions to enter into executive session are sufficient to comply with law, what they don't want to see is they don't want to see the word personnel, but they also don't want to see you parroting the language of the statute. So you have to find middle ground. You should take the portions of the statute that apply to your particular situation and make a motion based on that. And I'll use the example of potential disciplinary matters. So a public body would like to go to executive session because they've been made aware of allegations of misconduct against one of their employees, one of the employees of the agency. So an appropriate motion to enter into executive session may be moved into executive session to discuss employment history of a particular person and matters that may lead to the discipline, suspension, dismissal, or removal of a particular person. The public body is not required to identify the individual who's being discussed. That's sort of part of the reason for the executive session. You want to protect this person's privacy until there's been a discussion, until there's knowledge that there actually has been a finding of misconduct. But while in the first stages of the allegation, it's perfectly fine not to identify the individual who's being discussed. So that's what I mean about trying to be specific enough that you are showing that you know you're going in for a proper purpose, but you don't need to be so specific that you're defeating the purpose of the executive session. So I just talked about executive session, which is the first avenue for meeting behind closed doors, and a second avenue for meeting behind closed doors called exemptions. Section 108 of the Open Meetings Law talks about exemptions. And if an exemption applies, the Open Meetings Law does not. It's as if the Open Meetings Law does not exist. The three exemptions are: 1, judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals; 2, deliberations of political committees, conferences, and caucuses; and 3, any matter made confidential by federal or state law. The second and third bullets are the ones that come up a little bit more frequently. For example, if you have a 5-member town board and 3 of those members are Democrats and 2 of them are Republicans, those 3 Democrats can meet together and discuss whatever they want, whenever they want. They don't need to notice that they're meeting. They don't need to tell people why they're meeting. It's completely outside the confines of the Open Meetings Law. They can't vote, they can't take action, but they can discuss whatever they want, even though they constitute a quorum of the full board. There's case law that indicates that if you have a public body that is made entirely of a single political party, so again, if you go back to that town board and instead of it being a split board, you have a town board that is made up entirely of all 5 Democrats. I'm picking on Democrats just randomly. Please don't take any quotes reading into that. I'm just random picking this time. If you have all 5 members of a public body, or all members of a public body are members of the same political party, the courts have held that they have to limit their conversations that are held outside of an open meeting to political matters. And business and discussions relating to government matters, so public business, need to occur within the confines of an open meeting. It's just a distinction that's been offered by the courts, pointing it out there for any public bodies that are made up entirely of a single political party, that their committee meetings should be limited to political business, and they should refrain from having conversations that relate to public business unless they're having those conversations in the confines of an open meeting. Any matter made confidential by federal or state law. A very common example here is the attorney-client privilege. Conversations that are covered by the attorney-client privilege are made confidential by New York State civil practice law and rules. So if a public body needs legal advice from your municipal attorney, for example, they can meet behind closed doors with their legal representation for the sole purpose of requesting and receiving legal advice. And that conversation is covered by the attorney-client privilege. But the attorney has to be playing an active role. The mere presence of an attorney in a gathering is not going to be enough to assert the attorney-client privilege. The attorney has to be playing an active role in providing legal advice. Once the attorney stops playing an active role in that conversation, and once the public body wants to take that information and start deliberating about what to do next, the attorney-client privilege ceases, and the conversation needs to go back to being held in the confines of an open meeting. Non-compliance and enforcement. Committee on Open Government does not have enforcement authority. We do not have the authority to investigate complaints or to compel a public body or an agency to take any particular action. Enforcement of the Open Meetings Law is through the initiation by any aggrieved party of a Civil Practice Law and Rules Article 78 proceeding. If a petitioner substantially prevails, the court has the authority to award costs and attorney's fees. If the if the court determines that there's been a substantial violation of the Open Meetings Law, they can invalidate the actions. If the court finds that it's a mere technical violation, the likelihood is that they are not going to invalidate the action. However, there could be penalties such as the cost of attorney's fees, and one other provision is that a court can actually require a public body to receive training from my office. So if you have any questions about the Open Meetings Law or the Freedom of Information Law, anyone is welcome to contact our office by phone or by email with those questions. Whether you're a government employee, you're a member of the public, a media representative, our phone number is 518-474-2518. If you get voicemail, please do leave a voicemail. We do try to return those as quickly as possible, but just because we're a small office, sometimes you will get voicemail. And at the beginning of the program, I mentioned that there's an email address that reaches all of us. So this is a great email address to use if you have questions about the Open Meetings Law or Freedom of Information Law, because any one of the attorneys in our office, regardless of whether they're in or not, can respond. So it's COOG, which is our acronym, Committee on Open Government, coog@dos.ny.gov. So that is the email address where you can reach our office. So what I'm going to do now is I'm going to switch over. I'm going to stop sharing, switch over to the camera, and let's see, what I want to do is see the chat feature. So as I mentioned at the beginning of the program, if you have questions, you are welcome to add them into the chat feature. That's where I'll be looking for questions. And I'll remind everybody again at this point that a recording of this program and the training materials are posted to the Committee on Open Government's website. If you go to our homepage and scroll down a bit, you're going to see a block that says training materials and recordings. Click on that. You'll see copies of our PowerPoints. You'll see a link to our YouTube page, which contains our training recordings of the programs that I've been doing for the past couple of years. This one might take a little bit longer to get up on the website just because of the holidays, so just be patient with that. And I will try to get those up as quickly as possible. So if you have questions that we haven't addressed during the program, you can put them into the chat feature and I will start answering them now. If I have a question that I think I've discussed in detail during the program, I may skim over it a little bit. Also, if a question is very factually specific, I may ask that person just to reach out to me directly because I like to try to not waste everybody's time and make sure that we're addressing questions that are somewhat at least of general interest. Someone has asked, during privilege of the floor at a town planning or zoning board meeting, if a resident asks a question and submits the question right into the board, is the town required to reply? The answer is no. The open meetings law up until recently was completely silent with regard to public participation, public comment. If a public body chooses not to have a time set aside for public comment, public participation, that's permissible under the statute. There's no obligation to allow for public comment or participation during a meeting of a public body. And here I'll point out that meetings and hearings are two different things. A meeting is for the intent of the members of the public body to discuss and make decisions. A hearing, there's an expectation that you are reaching out to the public to get their input on a particular issue. The open meetings law only governs hearings to the extent that they are hosted by a public body. If the hearing is not hosted by a public body, the open meetings law does not apply. And the open meetings law is not going to govern the process for how public comment is accepted. So if a public body wants to establish a procedure or a rule that they will not answer questions during the public comment period, that's perfectly acceptable. The one thing I'll remind is that everybody should, if you have rules regarding public participation, those rules need to be applied consistently and fairly across the board. You can't let one person speak for 10 minutes because you like them or because they're talking about something that you're in favor of, and one person only speak for 2 minutes because it's the opposite, because maybe they're not a very nice person in your opinion, or because they are against a particular proposal that the board is in favor of. So you just need to, whatever rules you establish regarding public comment and public participation, it has always been the opinion of the Committee on Open Government that those rules must be established consistently and fairly across the board. The new amendments to the open meetings law with regard to extraordinary circumstances video conferencing add a provision that states you need to treat people that attend in person the same as you treat people that are attending virtually. You need to give those people that are attending virtually the same right to comment as you would someone who is attending in person. But if you're don't have a time set aside for public comment, you don't need to let anyone speak. Our next question is the library board subject to the open meetings law? They're convening a community board to advise them on a large new archive at the library. Community board does not have any library trustees participating. If this community board does not serve a statutory function, like for example, if it's not required to exist by New York State law, if it is merely advisory in nature, for example, they can come up with recommendations to the full board, but they don't have the authority to make decisions themselves. If they don't have any authority to spend library money, and they are not made up entirely or primarily of members of library trustees, then in my opinion, the likelihood is that community board is not going to be a public body subject to the open meetings law. The question, this is a good question, is do minutes have to identify why a member was granted extraordinary circumstances? And the answer to that is no. There's nothing in the law that states why, that the minutes need to include why a member was granted extraordinary circumstances. Like it doesn't need to say illness, it doesn't need to say caregiving, it just needs to say that they are participating via extraordinary circumstances video conferencing, but not why. Someone says, given we must post the transcript to our website, is there still a need to post minutes to the website? There is actually no obligation to post a transcript to your website. There's an obligation to post a recording to the website if you use extraordinary circumstances video conferencing. If the transcript only needs to be prepared upon request. With regard to minutes, again, I'll remind everybody you need to prepare minutes no matter what. Regardless of whether you have a transcript or recording, those minutes still need to be prepared and made available to the public. But minutes need to be prepared and posted to the website regardless of whether you use extraordinary circumstances video conferencing. So if you have a fully in-person meeting, there's no obligation to record, but there's still an obligation to prepare minutes and post minutes to the website. Let's see. So I apologize. Sometimes reading through the chat can get a little. Someone asks about if just giving the location of a hotel that one member of the local board is vacationing at enough to meet the requirements of a physical location at which the public may attend the meeting. Well, you want to give, I mean, if the hotel is serving as a secondary public location, you certainly want to give enough information in the notice so that the public knows where to go. Like, for example, if the person has maybe rented, reserved a small conference room or something of that nature, it should probably indicate that in the notice. Just as if, for example, when we have a meeting here at the Committee on Open Government, we don't just say the meeting's at 1 Commerce Plaza, Albany, New York, 12231. We say it's on the 11th floor, suite 1120. We're a 20-floor building with several offices. We don't want people wandering up and down the floors and through the building looking for the meeting. We try to be as specific as possible. And the same is true for any secondary location. Someone has a question about, I think, quorum here. If membership is 11, quorum is 6, can the body act with a majority of those present? No. You need to have a quorum of a public body to approve any particular action, to vote in favor of a particular issue. So if you have an 11-member board, quorum is 6, you need 6 members. Even if 6 people are the only people that show up at the meeting, you're still going to need all 6 of those people to vote in favor of a particular issue in order for an action item to pass. It's always going to be based, quorum is always going to be based on total membership, and the number of people needed to pass a motion or resolution is always going to be based on total membership. The number of people present at the meeting is somewhat irrelevant, except to the extent that you need at least a quorum present to even get going. If a town board does not post their minutes until 2 months after the meeting occurs, they're in violation of the Open Meetings Law, correct? Only the courts can determine whether a violation of the Open Meetings Law has occurred. I've advised that, you know, what is required under the statute, and that's what I can tell you, but I can't, only the courts can tell you whether there's a violation of law. Another question is, if I understand this correctly, boards are required to allow public participation remotely if a board member is participating remotely. Yes, we discussed this. Do they have to allow public participation if they offer a live stream but all council members are attending in person? No, the answer is no. They only need to allow public participation remotely if a member of the public body is attending using extraordinary circumstances video conferencing. Someone asks about, can I repeat the comments you made regarding ADA and reasonable accommodations? I can repeat it, but basically what I said is I don't have the authority to provide guidance. I don't have the expertise or the authority to provide guidance regarding the Americans with Disabilities Act, which is basically what I said. Last question, is there a requirement to post the rules in regards to public comments or not? No, there's nothing in the Open Meetings Law that addresses public comments, so there's no rule to post. There's no obligation in the Open Meetings Law to post rules because there's nothing in the Open Meetings Law other than that small provision under the extraordinary circumstances video conferencing that you treat virtual people and in-person people the same, but otherwise the Open Meetings Law is silent with regard to public participation. So that's the last question that I have in my chat feature. I thank everybody for coming today. If you do end up, oh, let's see, if minutes are taken during an executive session, are those minutes available to the public? Yes. The answer to that is yes. So people need to think when entity is preparing the minutes of the executive session, they want to keep in mind that that information is going to be public information, and prepare the minutes accordingly. So again, I thank everybody for attending today. If you do end up having individual questions about the Open Meetings Law or Freedom of Information Law, you know where to find us. Again, I will point out that a recording of this program will get up. It just might not be as quickly as normal. Will get posted to our website. I do have older programs that are fairly similar already posted to the website, and the PowerPoints are also posted on the website. Someone asked finally is, what court would you contact if the board is not posting minutes? It's litigation. If you want to bring an Article 78 proceeding in state Supreme Court because you believe there's a violation of the Open Meetings Law, that's litigation. You're suing the municipality, you're suing the public body. So it would be in one of the Supreme Courts that are set up across the state of New York. Okay, thank you very much. I appreciate everyone for attending today. I hope everyone has a happy holiday and a happy new year, and we'll maybe see you again in the new year. Thank you very much.